Jeffrey Basil is sentenced. A judge could send him away for 25 years to life behind bars on this second-degree murder conviction. Tampering with evidence carries a sentence of 2 to 4 years. Now, our News 4 legal analyst Terry Connors joins us now, looking at what happened in this very closely watched trial. Terry was with us at 5 o'clock. What was your reaction today when you heard this verdict?
Well, I think everyone had a little bit of surprise because most people thought the debate would revolve around manslaughter 1 or manslaughter 2. Obviously, the issue of intent was paramount in this case. The jury found that there was intent to cause death.
Now, talk about intent, because the jury asked for a reading of what intent means, but it means different things for different charges, right?
Well, the levels of felony charges, A felonies, B felonies, D felonies, revolve around what you intend to do. If you intend to cause the death of someone, that's murder. If you intend to cause serious physical injury and they die, that's manslaughter. And if you're reckless, a lesser degree of intent, that's manslaughter second degree. So it makes a big difference.
And they chose the harshest judgment there. What about the alcohol defense? I mean, the defense said from the beginning, this was a night when everybody was drunk, nothing good happens then. You can't really blame people for what they do when they're drunk. Does that fly?
Well, you can interpose an alcohol defense to say, I was intoxicated and I wasn't able to form specific intent. But voluntary intoxication is very, very difficult to persuade a jury. You're the one that made yourself drunk. You're the one that caused it. They're not going to cut you too much of a break on that kind of a defense.
Okay, I want to ask you very quickly. I did ask folks on my Facebook page, do you have any questions for Terry? A couple people want to know about the police officers in this trial. One testified, one didn't. What can happen to them?
Well, good question, and interesting twist in this type of a case, because you had one officer who did testify, cooperated with the prosecution and was a witness, and another officer who, as is his right, invoked his privilege against self-incrimination. So he did not testify, and that was outside the presence of the jury. So what's left now is the prosecutors can still look to determine, was there something that violated the penal law by these officers? If not, they can pass on that, and the officers could still be subjected to internal affairs investigations or nothing. So there's a whole range of options.
By the Buffalo Police Department
That's
itself.
true. They have that right administratively to look at their conduct.
All right, finally, the appeal. There will be an appeal. Do you expect things to change here?
Well, what makes an appeal different is it's judged solely and exclusively on the record. You look at the cold, hard facts. You don't have the emotion. You don't have any of the individuals involved, no testimony. 5 judges in Rochester sit back and say, does this record, do these words add up to murder? And that's a different situation.
Okay, we shall see. Terry Connors, we thank you so much for your insight and analysis. We appreciate it.